Akwa Ba, and a very warm welcome to Lex Aux. This is where we break down Ghanaian law for you, plain and simple. Let's dive right in.
Now, I want you to think about this for a second. Can a court take your home, your actual house, because of someone else's crime? And can they do it while that person's case is still being appealed? It sounds unbelievable, right? Well, that's exactly what we're talking about today.
Well, the good news is the Supreme Court of Ghana has just weighed in on this, and they've given a very, very clear answer. An answer that's absolutely crucial for protecting your property rights.
So at the heart of this huge legal battle is one person, Mr. KWESI OSEI OFORI. He's the man who found his home caught right in the middle of a criminal case that, believe it or not, had nothing to do with him.
Okay, so for our records, the official case name is the Republic versus the High Court, ACCRA, Ex Parte KWESI OSEI OFORI. It's a 2025 Supreme Court decision, and really it boils down to two big things: property rights and making sure our courts play by the rules.
So you're probably wondering, how on earth did an ordinary citizen end up in a showdown with the High Court over his own house? Well, it's a complicated story, but let's break down the timeline.
All right, so follow the timeline here. It all starts in May 2023. A man, David Asayate, gets convicted for money laundering. As part of that, the High Court orders a house to be given over to a company called Missile Energy as restitution. Simple enough, right? But just a month later, in June, Mr. Tay files an appeal. Now here is the crucial twist. The person actually living in that house, our applicant, Mr. KWESI OSEI OFORI, steps forward in December. He files a notice of claim, basically telling the court, hey, wait a minute, I am the lawful owner of this property. Now, you'd think that would pause things, right? Especially with an appeal pending, but no. In April 2024, the High Court actually convicts Mr. OFORI for contempt of court because he hadn't left the house. And if that wasn't enough, just 1 month later, Missile Energy tries to get him convicted for contempt for a second time.
Okay, so as you can see, this whole situation was getting really messy. It was this tangled web of events that made it necessary for the Supreme Court to step in and really clarify some big fundamental questions.
The Supreme Court basically had to untangle 4 key issues. First, when someone appeals a criminal case, what does that do to an order to hand over property? Does it keep going or does it pause? Second, is contempt of court even the right legal tool for taking possession of a house? It sounds a bit heavy-handed, doesn't it? Third, and this is a big one, can you just take property from someone like Mr. OFORI, who isn't even part of the original case, without giving him a proper chance to be heard? And finally, they had to look at the High Court judge's conduct and ask, was there a real likelihood of bias here?
So let's tackle that first question, because the answer reveals something really powerful that's already written right into our laws.
And you know what? The answer isn't hidden in some complicated legal theory. It's right there, plain as day, in Section 29 of the Courts Act. It says that when a notice of appeal is filed, the operation of that order shall be suspended until the appeal is finished. It's basically an automatic pause button built right into the law.
So what the Supreme Court is saying is this: the law is crystal clear. The very second David Tay filed his notice of appeal, that automatic pause button was pushed. From that exact moment, the High Court had no power, no jurisdiction to enforce that restitution order, which means everything that happened after that, especially the contempt charge against Mr. OFORI, was done without legal authority. It was simply unlawful.
If you are finding this useful, follow Lex Aux. We break down Ghanaian court decisions in plain language every week.
Okay, so we've established the High Court was acting without power. But the Supreme Court didn't stop there. They also went on to explain exactly what went wrong with the procedure itself and what the right way to handle this would have been.
And this is such a clear way to see the problem. You see, the High Court reached for the wrong tool in the legal toolbox. They used committal for contempt, which is really meant to punish someone who is willfully disobeying a lawful order. But the right tool, the one required by law, is a writ of possession. And that's not just a technicality. A writ of possession is a civil process, and it would have forced the court to do one absolutely critical thing first: actually hear Mr. OFORI's claim that he owned the house.
So since the High Court was acting unlawfully and was about to do so again, Mr. OFORI's lawyers used a very powerful legal move. It's called a prerogative writ of prohibition. The best way to think about it is like this. It's the Supreme Court holding up a giant red card to a lower court. It's an order that says, stop. What you are doing is outside your legal authority, and you must not proceed.
Okay, and a quick note here for the law students among us. This is a key point. Prohibition is a forward-looking remedy. Its job is to prevent a future illegal act from happening. This makes it different from its cousin, certiorari, which is backward-looking. Certiorari is what you use to quash or cancel an unlawful decision that's already been made. A very important distinction.
But the problems didn't end with jurisdiction or procedure. There was another, very serious issue here: the appearance of bias. You see, during the proceedings, the High Court judge said something quite revealing. She said that victors in cases must be allowed to enjoy the fruits of their labor.
Now, when the Supreme Court saw that statement, they found it deeply, deeply problematic. Why? Because it strongly suggested that the judge had already decided who the victor was. Her mind seemed to be made up in favor of Miss Energy even before Mr. Ofori, the man who was actually living in the house and claiming to own it, had been fully heard. That creates a clear appearance of bias, and that's something the justice system simply cannot allow.
So, let's bring this all home. What does this judgment actually mean? For you, for me, for the average Ghanaian property owner? Well, this isn't just about Mr. Ofori. This ruling sets up some really important guardrails that protect every single one of us.
Let's break it down into 4 key lessons from this case. First, remember that automatic pause button. An appeal in a criminal case matters, and it automatically suspends related property orders. Second, the right process is non-negotiable. You can't use a heavy-handed tool like criminal contempt when a civil process like a writ of possession is required. Third, and this might be the most powerful takeaway, third-party rights are sacred. If you have a legitimate claim to a property caught up in someone else's case, the court must give you a proper hearing. They can't just brush you aside. And finally, justice has to be impartial, and it has to be seen to be impartial. Our judges cannot prejudge a case, and we have checks like the writ of prohibition to make sure of it.
But really, all of these points, all 4 of them, are built on one single fundamental principle of justice.
It's a rule that is the very bedrock of our legal system. You may have heard the Latin for it, audi alteram partem. It simply means, hear the other side. And what the Supreme Court did in this case was to powerfully remind everyone that here in Ghana, no one, and I mean no one, is to be punished or have their property taken away in court unless they have first had a proper opportunity to be heard.
So, as you can see, this is a huge decision for property rights and for the rule of law in Ghana. It really reinforces the protections we all have, and it leaves us with a question for you to think about. What other safeguards do you believe are necessary to protect property owners when they get caught up in these kinds of legal disputes? Drop your thoughts in the comments below. We'd love to hear from you. I really hope you found that breakdown helpful. For more clear explainers on Ghanaian law, please be sure to like this video, share it with your friends and family, and follow us at @LexOx on TikTok and at GH Case Explainer on YouTube. We have plenty more cases coming your way. Stay safe and stay informed.